Location differences do not suffice exclusion, nor does one unfortunate event define her as a human being and mother to her son. Just prepping you for what we're about to get into. I hopped on the Sarah Boone subreddit, and what was waiting for me? Sarah Boone's written closing argument. Let's see what she wants, what she has to say, and how little she actually listened to her own case. Because I have guesses that she is going to just argue the same things that she was told no to. So, respondent Sarah K. Boone, and in her best representation and efforts, submits her closing arguments in opposition of the petitioner's parenting plan, amended and support orders, and all other requests the petitioner is attempting. Opposition states as follows. To begin, the respondent would like to address the section of alimony and the petitioner's motion for modification of alimony, filed April 12, 2022. Respectfully, before this honorable court considers this request, the respondent asks that judicial notice be taken of her pending motion for contempt. Wasn't that already squashed? I might be wrong. It's been a while. Wasn't that already like not a thing? Wasn't contempt already off the table for this? Filed April 11th, 2023 against the petitioner, whom has willfully failed to comply with court-ordered alimony obligations by neglecting to pay ordered alimony to the respondent prior to filing this petition to modify. Under Florida law, alimony obligations are court enforceable and cannot be ignored without consequence. Section 61.08 Florida states governs the award of alimony, and when such an obligation is established, the paying spouse must comply, absent modifications by the court. Further, Section 61.14 Florida statutes explicitly allows for enforcement actions and contempt proceedings when alimony remains unpaid. Florida courts have constantly held that failure to pay court-ordered alimony constitutes ground for contempt. As these obligations are not optional, they are legally binding. And then we have a bigger font here. It is important to take note that the form... I love how we don't even get her, like, handwritten stuff anymore, but she still boons it up, right? Because she made it bigger. It is important to take note the former husband, Brian C. Boone, was employed full-time during the entire 2 years that he did meet the requirements of his court-ordered alimony payments. The petitioner cannot, in good faith, request a downward modification while simultaneously standing in violation of the very court order they now seek to alter. Equity demands that one must come before this court with clean hands. Sarah, you're a murderer. There's blood on them. And the petitioner's non-compliance bars them from the relief they request until such arrears are addressed. Now, this isn't my highlight. As I said, this came from the subreddit. In the second portion of the petitioner's request, he takes this court to impute income to the respondent for purposes calculating child support obligations. Respectfully, this is improper to do under both Florida law and authority from other jurisdictions. Okay. This issue has been addressed in the Department of Revenue versus Lamas. I'm sorry, it's like hard to read, but I'm trying to make it so it's still on the screen, but it's like at a wonky angle. You know what I mean? So it was hard to like fit it in. The Lamas decision, I'm gonna call it Lamas. The trial courts cannot impute income to an incarcerated individual absent a showing of the ability to pay. The decision aligns with the pervasive authority, such as Lambert v. Lambert, where the Indiana Supreme Court concluded that imputing income as an incarcerated individual is improper because such individuals lack the present ability to earn income. That's an Indiana Supreme Court? Does she think she's in Indiana right now? Like, I know they can, like, I believe judges and stuff can, like, look at other state Supreme Court decisions, but it's still not a Florida decision. Respondent in this case is serving a life sentence, and there is no evidence or present or future ability to generate income. Florida law on child support recognizes that obligations must be based on the actual ability to pay, not on speculative or non-existent income. Sarah, honey, you have income. Your medicinal honey buns, the people giving you money, that's income. Now, is it going to be income for child support? I don't know, but that's income. To impute income here would not only contradict established law, it would create an artificial support order that the respondent has no capacity to ever be able to fulfill. So, I just want to understand here. Brian has to pay everything because Sarah says to. Sarah doesn't have to pay because she wants to keep her money. Okay. Okay, let's just keep going. With respect to the nature and purpose of child support, it is important to emphasize that child support exists for the best interest of the child, not as a punitive measure against the parent. Section 61.3 Florida statutes establish that child support guidelines and sets forth that child support is always designed to meet the needs of the minor child. The Florida Supreme Court has repeatedly underscored the focus of child support orders must remain on the child's welfare and not on creating financial leverage between parents. Sarah, you tried to get child support money while you are spending life in prison as leverage. And you tried to argue that you don't have to spend that child support money on anything that for the child, it's how you want to spend it. You argued that. Unless I'm wrong, that was argued in one of her filings. The petitioner further requests that if the respondent is awarded any monetary relief, such relief should be retroactively offset against alleged back child support obligations. Respectfully, this position is legally and equitably unsound. To allow such an offset would defeat the entire purpose of child support. Child support is a vested right belonging to the child, not the parent, and Florida courts have long held that these rights cannot be waived, bargained away, or retroactively manipulated to serve the financial interests of one parent over the child. This is amazing. Your Honor, even if this court were to accept the petitioner's request to impute income to the respondent and allow any relief owed to her to be offset against alleged arrears, the outcome would still provide no monetary support to the minor child, unless they take away your medicinal honey bun money. Instead of benefiting the child, as Florida law requires, the result would simply call it even, erasing petitioner's arrears while simultaneously depriving the respondent of funds she is legally entitled to receive. Question, because I don't know the answer to this. Can you take money from alimony and require that money be given as child support? Because if so, Sarah is saying, I have no income, therefore I don't need to pay child support, but also I would like this income to be given to me. Is that why she's arguing this point first? Because she's like, I can't argue that I don't have money and then argue I should get money. In effect, this approach would punish her for the petitioner's past noncompliance and reward the petitioner by relieving him of obligations already legally established under Florida law. The controlling principle is clear. Child support exists for the benefit of the child, not a financial tool for either parent. To permit such an offset would shift the focus away from the child's welfare and toward the petitioner's personal gain. Kind of like how you wanted to still have child support, and then you wanted to have the child support money, but you wanted to control it purely to have leverage, undermining both the purpose of child support and the equitable enforcement of court orders. For these reasons, the respondent respectfully requests that this honorable court deny the petitioner's motion for modification of alimony, deny the request to impute income, and deny this request to retroactively offset any potential relief against alleged child support obligations. Here we have the petitioner's parenting plan suggestion. The respondent in opposition requests the following. So we just got through how things are supposed to be for the best interest of the child. Now we get to see how it's really about the best interest of Sarah Boone and making her child go to a prison to see a murderer. The respondent does not agree with the petitioner's amended parenting plan due to it not being in the best interest of the child. Oh, really? The respondent is avidly seeking to be included in her son's life in every aspect possible. That would be basically no aspects because you murdered someone. And in accordance with Florida law, respondent should not automatically have her inclusion as a parent to continue to raise, contact, and participate in his life removed, deterred, or reduced due to incarceration. Location differences do not suffice exclusion, not does one unfortunate event Location differences do not suffice exclusion, nor does one unfortunate event define her as a human being and mother to her son. Hunter v. Hunter, states the court ruled that shared parental responsibility must be honored unless proven harmful to the child. And I know I got quiet and I know I moved past it, but if I say the things that I want to say after she made that statement, I might not have a channel anymore. The respondent is emphatically asking for this responsibility to utilize in her greatest capacities currently available, regardless of location differences, which she can fully be successful in and continue to enrich her son's life even more. Ceaselessly upholding her rights as a child, his rights as a child, even while at DOC, in which he avidly invites and welcomes every day. Oh my, she is in communication with him. Oh my fucking God. She is arguing she shouldn't be defined as being a convicted murderer. It's a mistake. And now she wants daily contact with the son. Florida statute 61.13 affirms both parents have equal rights to participate in the child's life unless clear and convincing evidence proves harm to the child. Sure. You're a murderer. You don't care about money going to him. You want it to go to you. Brian has made it very clear that you are manipulating the child and he doesn't want to speak to you on many occasions. And then on top of that, you are wanting him to do daily communication. The primary reason for the request of a guardian ad litem, the respondent was repeatedly denied to emphatically prove there is no such evidence. Yes, there is. Wait, no, sorry. I misread that. So her request for a guardian ad litem was denied. The child could also have reaffirmed his praise. The child also could have reaffirmed his praise for their relationship, which he knows will grow in another positive level once applications for his visit are finally received, where both mother and son can be reunited in person. By the way, I saw someone on the subreddit, I don't know if it's accurate, but they were going through like things for that prison. The son might have to get strip searched to visit her. For major decisions in the child's life, the respondent should be included in his growth as a young adult, which can help shape him into being even greater, more open-minded, loving, and successful. No, you cannot do that, Sarah. You can't do it in prison, and you sure as hell couldn't have done it out of prison. Both parents must be consulted on major decisions unless an emergency arises. And we know that everything to Sarah will never be an emergency. She wants to hold this over Brian and hold this over the son. And it'll be like, oh, the son wants to go to baseball camp. And Sarah will be like, no, because I didn't get my medicinal honey buns. We know that's what she'll do. The respondent's mind, heart, and soul, overall, being which lives for her son, still computes love, understanding, and compassion, knowledge, wisdom. I legitimately almost threw up there. I'm getting heated. I have a video, okay, coming out some point. I've already recorded it, right? And then this dropped in my lap. I was heated in that video. This one's doing it too. It's not good. The respondent's mind, heart, and soul, and overall being which lives for her son, still computes love, understanding, compassion, knowledge, wisdom, goodness to provide to her son's life, no matter where she is. She desperately wants to be included and has not been since her incarceration, where withholding of such redeeming qualities to her son from the respondent have been due to petitioner's ongoing decision to alienate her. Holy shit. Sarah would have been better off not submitting this. This shows she should not be near that child. Oh my God. Between parties, not to reward a party acting in bad faith, the respondent additionally asked this court to This is cut. There's something cut here. That's just how it arrived to me. Between parties not to reward a party acting in bad faith, the respondent additionally asks this court to strike or dismiss the petitioner's request as nothing more than another improper attempt to evade his obligation to pay long-standing alimony arrears. Furthermore, the petitioner alleged the respondent is the party who has caused chaos and delayed these proceedings. Sarah, you have never been involved in a court case that has not had chaos and delays. You are the factor. How many lawyers are we through? And the common factor is Sarah fucking Boone, right? At some point, you find the common denominator. Respectfully, this assertion is contradicted by the record. On April 18, 2023, it was the petitioner himself who filed a motion for continuance. They had to wait for your murder trial. This dumb bitch. God damn it. You murdered a man. God damn it. They literally had to continue because you murdered someone. Despite the fact the respondent was prepared to have all pending motions heard more than 2.5 years ago. The respondent firmly rejects petitioner's baseless allegations he is the cause of delay. Moreover, the choice to retain private counsel is just that, a choice. He doesn't want to deal with you directly, Sarah. No one does. It's not a choice, it's a requirement. It is painful for me to deal with you at this distance. I can only imagine him. This is a civil matter, and no party is compelled to hire an attorney. Thus, the petitioner's voluntary decision to incur legal fees should not be shifted on the respondent, particularly when he is already delinquent in meeting his court-ordered support obligations. I don't think that's how it works, Sarah. Legally, I don't think that's how it works. To award fees in this context would effectively reward the petitioner for noncompliance and penalize the respondent, an outcome which is wholly inconsistent with principles of equity and fairness under Florida law. You know, she loves to use the word equity, but I'm just going to take a guess that if you were to reword it as DEI and mention that as the equity, the E from that, she'd be against it suddenly. The respondent wishes to remind the court that the petitioner alleged to have paid for a storage unit for 2 years. Okay, but has failed to provide any evidence of this. Well, Sarah, it's really simple, right? Right? Let me break this down for you. Do you have anyone that asked to go to the storage unit for 2 years? No? No. Because if you did, they could have photographed it not existing or gotten evidence. No, you didn't. You see, because you didn't actually care about that stuff beyond making him pay for it. Therefore, his request to have this deducted from any money relief I may be awarded should be dismissed. For any foregoing reasons, the respondent, Sarah K. Boone, respectfully requests this court find the petitioner in civil contempt for violating the court-ordered payments he was ordered to pay while he was employed, and order the petitioner pay $26,000 in alimony and $2,314 in interest under Florida law, deny the petitioner's request that he calls even that imputes an income to the respondent for child support, deny the petitioner's proposed parenting plan, and grant the respondents in place of. And this was all filed. It says, respectfully submitted on the second day of September 25th, and in all gratitude of his honorable court's patience. That is almost a month ago. So if it was actually submitted, I don't know. Jeez. Literally, she's taking this. Sarah Boone is taking this and saying, look, my son should call me every day. I'm broke. I have no way to get money. Also, I'm broke. I need almost $29,000. Because my medical honey buns, I think she would have been better off not submitting this. She has made an amazing argument that she should be nowhere near that child. She's made an amazing argument that if she did get awarded anything, it should just go to Brian. It's everything I expected. It really is. Maybe not. Maybe it's more than I expected, right? I like the little font. She used small font. I like that. She deserves nothing. I hope you enjoyed the video. If you did, like, comment, subscribe. Um, I have something else coming out that's already pre-recorded. It was gonna come out. Literally, it's edited, everything, and then this happened. I might release it later tonight, so watch for that. And for the next couple days, if there's a decision, I'll try to find it, but I might be a little tuned out because I bought uh, I bought Silent Hill out to make content for my gaming channel. I did some. I'm gonna be honest, I don't like the game at all. So that's $80 down the drain. And then they got a new Digimon game coming out tomorrow, and I'm like, well, this looks fun. Maybe some content there. So I bought that for like $60. And then I've got Pokemon on the 15th for like $60. So yeah, just those are dates I'm going to be busy, right? I'm not going to be doing anything probably true crime related around that time. So just know the next few days, if we get a response from the judge, I'm probably not going to be the first to say anything. It's probably going to be very delayed. Um, I just don't want her to get anything. She makes such a compelling argument that she deserves nothing.